for clicking this video. This is Battle with Ola and my name is Mujola Olua, and in this video I want to talk about 14 instances or circumstances wherein or whereby a party can come to court and ask the court to dissolve their marriage that is not up to 2 years. So if you're a Nigerian, or if you have conducted your marriage in Nigeria under the Marriage Act, or if you're interested in Nigerian family law, especially as regards matrimonial causes, this video is for you. What we want to talk about are the exceptions to the 2-year rule. In Nigeria, there's something called the 2-year rule for marriage, which means that you cannot come to court and ask for dissolution, a decree of dissolution of marriage, if your marriage is not up to 2 years. I keep getting questions from people wanting to dissolve their marriages that are not up to 2 years old. I've even had a party ask me about dissolving a marriage that is just about 4 months old. It's really saddening when you think about some of the circumstances that lead up to these decisions or these desires to dissolve marriages, but it is what it is. So again, like I always say in most of my marriage related videos, this channel supports marriage. This channel believes in the institution of marriage, and the person speaking believes in the institution of marriage. So none of these videos that I make about marriages are about championing a cause for divorce or dissolution of marriages or ending marriages. No, but we need to talk about the law as it is, so that you know what to do, or you know how to counsel other people if the situation ever applies. So we want to talk about exceptions to the 2-year rule. The court says that you cannot come and ask for a decree of dissolution if your marriage is not up to 2 years. And of course, you would have to prove that to court because you present a marriage certificate and the date will be calculated. But now the court is also saying, or the law, the Matrimonial Causes Act is also saying that even if your marriage is not up to 2 years, you can still come and ask for a decree of dissolution in any of these 14 circumstances. So it could be a decree for nullity of marriage as well in some circumstances, and it could be a decree of dissolution of marriage in some other circumstances. I've done a video on dissolution of marriages, and I've done another video on void marriages, nullity of marriage. Please watch these 2 videos. I'd like to say that most of these circumstances boil down to one factor: fraud, deceit, pretense, obtaining by false pretense. So if it were up to me, I would say that in some of these instances, even after you've gotten a decree of dissolution or nullity of marriage, so the guilty party should be picked up by the police and prosecuted for obtaining by false pretense under section 419 of the Nigerian Criminal Code that applies to southern Nigeria. But that's just an opinion. So let's talk about these 14 instances or circumstances. The first one is if the person you got married to was lawfully married to another person at the time the marriage was celebrated. So you did not know, but this person was lawfully married, that is a marriage that is recognized by law. They were already in that kind of marriage, and then they went ahead to marry you as well. Then you can come to court and ask for you can come to court before the 2 years that the court originally stipulated. So you can come to court in that instance. Second one is if the celebration of the marriage did not comply with any of the requirements stated in law, and those requirements will be found in the Marriage Act and in the Matrimonial Causes Act. In the video I did on void marriages, I talked about how it's the minister of the place of worship. If you're doing your marriage in a licensed place of worship, for instance, it is the minister, the licensed minister, licensed to join couples, that should join the couple, not some invited guest minister or just anybody. For instance, if that was not the case when your marriage was celebrated, you can come before 2 years to ask the court to put an end to the marriage, and you would be right in so doing. The third reason would be if the consent was obtained by fraud or pretense. So if your consent to enter into the marriage with the person was obtained by fraud, that is, they misrepresented who they really were to you or what the circumstances were to you, or they pretended to be who they were not, or pretended that a certain state of things that influenced your decision was what it was not, then you can come to court before 2 years to ask the court to end the marriage. if your consent was obtained by fraud or duress. The fourth circumstance would be mistaken identity or nature of the ceremony. So if, for instance, you went in your own heart, you went to a birthday party and you came back married, that means you did not know what you were going to do or what you were getting into. Or maybe they told you that, oh, you're going for an homecoming party, and it turned out that you were actually going to celebrate a marriage. So if you did not understand the nature of what you were getting into at the time you got into it, or there's been a mistaken identity of the person that you thought you were getting married to, you were mistaken as to their identity or as to the nature of the ceremony being conducted, then you can come to court and ask the court to end the marriage. The fifth circumstance is when or in a situation where a party does not possess the mental capacity to understand the nature of a marriage contract. In that instance, the marriage can be brought to an end before 2 years. The sixth circumstance would be if either party is underaged. In Nigeria, there's a Child Rights Act that has put the age of marriage at 18 years. But not all states have domesticated this law. But generally, we'll put the age at 18 or whatever age applies in your particular state. So if either of the party has not attained that age, the marriage can be brought to an end before 2 years. The seventh circumstance would be prohibited degree of affinity or consanguinity. I talked about this extensively in the video on void marriages. So if either of the parties are within these degrees, that is, if you've married your blood sister or your blood brother or your step sister or step brother, those degrees, they are stated in law. If you're married within that range, the marriage can be brought to an end before it is 2 years. Then the next one is if either party has a venereal disease. A venereal disease would say that an STD, for instance. And it can be proven that they had this disease at the point of conducting the marriage and not contracted from the other party, then the marriage can be brought to an end before 2 years. Now, in this instance, time is of the essence, because if someone has a venereal disease before getting into the marriage, you cannot wait for 2 years or probably even a year before you bring such a matter to court. You should bring it to court as soon as it is discovered. That's the eighth circumstance. The ninth circumstance would be where one party, especially the wife, was pregnant for another person that is not the husband of the marriage at the time of conducting the marriage. So if you find out that the person you married was pregnant at the time the marriage was conducted, and you did not know, and they got married to you, and the pregnancy is not your own, you can come to court and ask the court to end the marriage even when it is not up to 2 years. For this one too, time is of the essence. So as soon as discovered, you take steps and set the ball rolling. That's the ninth reason. If either of the parties is of unsound mind or has epilepsy at the time of conducting the marriage, then the other party can come to court and ask the court to end the marriage because they are of unsound mind. Maybe they are suffering from insanity, from bouts of epilepsy or insanity. The marriage can be ended before it is 2 years. Now, in most of these cases, the party asking the court to end the marriage has to show that they did not know about these things at the time of getting into the marriage. Yeah, because if you have condoned, if you have connived or colluded, you cannot come later and cry wolf. No. The 11th reason or circumstance would be where a party cannot consummate the marriage. Consummation means coitus between parties. So the law assumes that coitus is not already taking place at the time of celebrating the marriage. That's why this kind of reason is present. So if after the marriage, one party cannot consummate because of, say, erectile dysfunction, and the other party did not know this at the time of getting into the marriage, this is something I've witnessed in court, as a reason for asking for a decree of dissolution. So the other party can come to court and ask for a decree of dissolution of marriage. So that's the 11th circumstance. The 12th circumstance would be where a party is deliberately refusing to consummate the marriage. So there's no known hindrance or obstacle to consummating the marriage, but one party is just refusing to to have sex with the other party, then that party that is being punished in that way can come and ask the court to end the marriage so that they can move on with their life. Because one of the important signals, or say factors, or say markers of a successful marriage, or a successfully celebrated or established marriage, would be coitus. Is part of what comes with the package called marriage: companionship, coitus, and several other things. So if a party is willfully and deliberately refusing to consummate the marriage, the other party can come and ask the court to end the marriage, and it has to be and the court would allow this when the marriage is not up to 2 years, because it works hardship on the party that is being punished, so to speak, to be asked to wait for 2 years before they can get out of that kind of situation. The 13th reason or circumstance is adultery. So where there's one party has committed adultery and the other party finds it completely unbearable, intolerable to live with them or continue the relationship, they can come to court before 2 years and ask the court to end the marriage. And the last one are the three the three reasons: rape, bestiality, sodomy. Rape, forceful carnal knowledge of a person; bestiality, having sex with a beast or an animal; sodomy, having sex with the same sex. So if any of these conditions are in error, a party can come to court and ask the court to end the marriage. The reason why the court will allow a party to come to court and ask for a decree of dissolution or nullity of marriage, in these 14 circumstances, is not far-fetched. When someone is getting into a marriage, many or most or all of these reasons, circumstances are not envisaged. So the court will not really support hardship if you can prove it, of course. Also, the court put the 2-year rule there so that people will take the institution of marriage serious, because it is a very sacred institution. It's the foundation of the society. So the court put the 2-year rule there to protect the sanctity of marriage. But where it can be established that staying in the marriage would work hardship on a party that's a victim, so to speak, now in that marriage, and or work depravity, or aggravate terrible conditions, the court will grant leave for a party to come and ask the court to end the marriage. The existence of any of these circumstances is not an automatic way out of a marriage in Nigeria. Rather, a party will still have to come to court by way of a motion ex parte, asking for leave to come and ask for a decree of dissolution of marriage, citing these circumstances with proof. So discretion belongs to the court. If the court is persuaded that you have a case, that these circumstances actually exist and are working or is working hardship on you, the court will grant you leave, and then you come and file your dissolution proceedings. You come and file your divorce papers, as laymen call it. So that's all I want to talk to you about in this video. The first is that if you get into a marriage in Nigeria under the Act, as the Act protects you, the Act also constrains you and compels you to stay in the marriage for at least 2 years before you can come out of it. And even if you want to come out of it, you have to cite facts. The omnibus ground is that the marriage has broken down irretrievably, but you have to cite facts in support of this before you can come out of it. So if you have other facts, but if you fall into any of these 14 circumstances, you can come before 2 years, and if the court is persuaded that not granting you leave to come and ask for a decree of dissolution will work or is working hardship on you, the court will grant you leave, and then you can come and file for dissolution, and you will be free even if the marriage is not up to 2 years. I will see you in my very next video. Don't forget to subscribe to those.